The worst part of a 50-50 LLC deadlock is not the fight with your partner. It's not the frozen bank account. It is what happens when you finally get fed up and run to court to fix it. Because in Florida, the member who files to break the deadlock can end up being the one forced out of the company. In this video, I'm going to explain exactly how to resolve a 50-50 LLC deadlock in Florida. By then, you will know your real options, the order to use them in, and the one move that can backfire on the person who makes it. All right, let's dive into this one. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. Now, I have watched two partners with equal ownership turn a healthy company into a hostage situation. And almost every time it traces back to the same gap. I call it the 50-50 trap. And in a few minutes, I'm going to show you the exact court remedy that can turn the trap against the person who springs it. But first, you need to understand what a deadlock really is, because it is not just an argument. A deadlock happens when two members each own half the company and neither one can outvote the other. Right now, you might be thinking, well, we just disagree sometimes, that's normal. But a true deadlock is different. It is when a real decision has to be made and the vote is 1-1 and nobody can move. Hire or fire somebody, take a loan, sign a contract, dispute profits. In a 50-50 company, any one of those can freeze the entire business because there is no tiebreaker built in. And here's the part most people get wrong. They assume a judge will simply step in and pick the better partner. That is not how it works. Florida courts do not run your business for you. When there is no operating agreement and handles deadlock, your company falls back on the default rules of the Florida Revised Limited Liability Company Act. And those default rules push you towards outcome you almost certainly do not want. Let me show you the first and best place to look before any of that happens. The first place to look is your operating agreement, specifically a deadlock sale provision. This matters more than people realize. Florida Statutes section 605-0702 says that if your operating agreement contains a deadlock sale provision and you initiate it before a court rules on dissolution, that provision controls instead of the court. In other words, your own contract beats the courthouse. So what does a good deadlock provision actually look like? Well, it can take several forms. One is a buy-sell clause, sometimes called a shotgun clause. One member names the price. The other member must either sell at that price or buy it at that price. It forces a fair number because nobody wants to lowball when they might be on the buying end. Another option is a mediation or arbitration clause where a neutral third party breaks the tie. And another is a simple tiebreaker, like a neutral manager or an outside advisor who casts the deciding vote. But here's the problem. Most 50-50 owners never put any of this into writing. They started off as friends. They trusted each other. And trust is exactly what fails first when money is on the line. Now, if this is already clearing things up for you, do me a favor and hit that like button and subscribe. It helps other business owners find this information who need it most. All right, let's get back to it. Now, let's say you did not have a deadlock clause. You're not stuck yet. The cleanest resolution is still a private one. One member buys the other out, or you agree to sell the business and split the proceeds. I know what you're thinking. We can't even agree on a vendor. How are we going to agree on a buyout? That is exactly why you bring in a neutral third party. This is where mediation earns its keep. A skilled business mediator does not pick a winner. They build a deal both sides can live with, usually around price and payment terms. Do not let a deadlock sit and rot. Every month the company is frozen, it loses value, customers drift, and the eventual buyout numbers shrinks for everybody. But if your negotiation truly fails, you are left with the court. And this is where the trap I mentioned at the start finally springs. So watch closely. The court path is what I call the nuclear option. Under Florida Statutes section 605-0702, a member can petition a court to dissolve the LLC on the grounds of deadlock. But you cannot just say you're frustrated. The statute requires you to prove three things: that the members are deadlocked, that you are genuinely unable to break the deadlock, and that irreparable injury to the company is threatened or already happening. Now, if the judge agrees, the company can be wound down, its assets sold, and the proceeds split. Now, this is the death of the business. The thing you both built gone, often for far less than it was worth as a going concern. So you might be thinking, fine, if we can't fix it, at least dissolution is a clean exit. And that is the assumption that gets people hurt. People filing for dissolution does not guarantee you walk away with cash. It can hand the other side a weapon. And here's how. Now, this is the move I promised you, the election to purchase. Florida Statutes section 605-0706 says that once you petition the court to dissolve the company or the other member can elect to buy out your entire interest at fair value. Not the company's interest, yours. And they can file that election within 90 days. And once it's filed, it is generally irrevocable. And you usually cannot just drop your case and walk it back. And the fair value is measured as of the day that you filed. Now think about what that means. You marched into court to end the partnership. Instead, the other side raised their hand, said, we'll buy him out. And now you're the one being removed from the company that you co-founded at a price a court sets. That is why the dissolution petition is not a threat to wave around lightly. The partner who thinks they are pulling the trigger sometimes discover that we're standing in front of the barrel. So here's the order that actually protects you. First, look to your operating agreement and any deadlock provision in it. Second, try a negotiated buyout with a mediator if you need one. And only as a true last resort, the courthouse, with your eyes wide open about the buyout that can flip on you. And if your 50-50 company does not have a deadlock clause yet, do not wait until you're frozen. Put one in now while you and your partner still get along. It is the single cheapest insurance policy in business. Now, this video is educational, not legal advice, so talk to a Florida business attorney about your specific situation before you act. Now, if this video helped you, like this video and subscribe so the next one finds you when you need it most. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.